idea that a state could say, like Michigan, we're going to ban racial preferences, judge people by the content of their character, not the color of their skin. Andrea Mitchell and her legal guest disagree. Roll it.
What is your impression of this? Because the ruling was not on affirmative action per se. It was on the right of a state to hold a referendum.
Well, of course, many people will interpret this as an affirmative action decision, but this really is a case about restructuring the political process in a way that disfavors racial minorities. And the doctrine of political restructuring actually comes to us from the decade after Brown versus Board of Education, when so many jurisdictions tried to create higher hurdles for minorities who were seeking to enforce the promise of Brown and seeking to enforce equality. Well, the same thing happened after the Supreme Court decided the Grutter case in 2003, which upheld the constitutionality of race-based affirmative action that's narrowly tailored to meet a university's compelling interest. You then had efforts by activists, including Ward Connolly, who had been successful earlier in California in passing a referendum, to take his show on the road. And Michigan was one of the 5 states where he was successful in helping people kind of get excited about the idea of opposing affirmative action. But the problem with it, Andrea, is that it essentially creates a higher hurdle for those who seek to deal with the issue of race and admissions. They would have to amend the Constitution to allow universities in Michigan to consider race and admissions, while athletes and alumni and others can simply lobby the Board of Regents, can lobby the university, can use the normal political processes to have their concerns heard. And this is precisely what the political restructuring doctrine, which the court really gutted today, was meant to eliminate.
Sherilyn Ifill, the legal guest, providing that analysis. So, Hans, was that a fair characterization of what the court ruled on? Because I know you wrote about the Grutter decision at the time, and I remember Sandra Day O'Connor speaking to a time limit on that. Was the time limit the issue here? Have we reached the time limit for these preferences to go away, or is this merely just a state's, the ruling was a codification of the state's right to determine when that time limit ends?
That's it exactly. And Ms. Ifill, I've actually debated her before, and she really didn't give that accurate a history of what's going on here. What the Supreme Court said is, look, if the voters of Michigan or any other state debate and then vote and decide that they want to ban all racial discrimination, they can certainly do that. And they overturn this really bizarre, and that's the only word for it, decision by the lower courts that said that if a state mandates equality, mandates equal protection under the law, that's a violation of the Equal Protection Clause of the U.S. Constitution, which is just, frankly, a nutty decision. And that's what Ms. Ifill was trying to uphold, was saying that's the way things should be.
Interestingly enough, we've heard, I played the clip earlier about opening up Pandora's box, and Sherilyn Ifill, actually, I do this because I want to provide you the opportunity to respond to it, but she made the case, hey, if you read one thing, if you hear one thing, hear Justice Kagan's dissent, and here is part of that dissent. Roll it.
Reviewers read nothing else. They should read Justice Sotomayor's dissent in this case, joined by Justice Ginsburg, because Justice Sotomayor, I think, presents to us the most powerful articulation of the ongoing issue of race in our country and the crossroads that we stand at. There's a whole section of her opinion that basically derides the majority for trying to sweep race under the rug, for pretending that if we just wish it away, as she says, that it will go away. But she says race matters. And I'll tell you one of the lines she says, race matters to a young man's view of society when he spends his teenage years watching others tense up as he passes, no matter the neighborhood where he grew up. Race matters to a young person addressed by a stranger in a foreign language which he does not understand because only English was spoken at home. Race matters, she finally concludes, because of the slights, the snickers, the silent judgments that reinforce that most crippling of thoughts: I do not belong here. And this, to me, is the most powerful articulation of where we stand on race in this country and of America's ongoing need to grapple with this reality. She says we can't wish it away, we can't pretend it doesn't exist, and actually the efforts by 58% of Michigan voters to essentially undermine the Supreme Court's decision in the Grutter case is a powerful, frankly, example of the way in which race still does matter.
All right, I'm a little confused there, and you can probably tell you said recused Justice Kagan's dissent. No, it is obviously Sotomayor's and Ginsburg's dissent. But the points that they are making, Hans, were similar to the Grutter case, which you wrote about. And again, if you could answer the dissent, because that is the one that's being talked about why they still need to violate, ostensibly, it seems to me, the Equal Protection Clause.
Yeah, see, I frankly just cannot understand those arguments. Look, what the people of Michigan said is we do not want race taken into account in college admissions. Now, that means that not only can colleges not discriminate in favor of, for example, black college students, but they can't discriminate against them either. And so if you're putting in a policy that says that everyone has to be treated equally, that you can't take race into account either for or against people, you know, how in the world does that put black Americans, for example, at a disadvantage? I mean, that is, in fact, what Martin Luther King worked so hard to try to achieve, was for black Americans to be treated equally, just like other Americans. And that's, in fact, what the citizens of Michigan voted to do.
They also spoke in another segment with CNN's Carol Costello and the legal analyst there, Johnson, I believe her name was, speaking to Pandora's box of this is going to undermine women's rights. This is going to be used to undermine homosexuals' rights. And I guess they're speaking to changing the definition of marriage or something along those lines. When you change the definition, it no longer means what it did, and so you dissolve the definition. But I digress. Hans, could you speak to that?
Oh, they're correct when they say it will undermine special rights. Because what they're saying is that they believe it's okay for the government to discriminate. Mm-hmm. Now, it's okay for them to discriminate in favor of some groups and against others. So they want special rights accorded to different individuals based on their gender and their race. So they're basically saying they're in favor of government discrimination. And this interferes with that. That is certainly right. But not in the way they're claiming.
It seems that we are seeing the death of, and it seems the death of liberalism, quite frankly, that we know it, modern day liberalism, because we're seeing the fact that here's what we want the law to do, which is not provide special rights and not special concessions. And we want to be equal under the law. And their greatest campaign line is to highlight alleged discrimination. And they've done that in numerous ways, including the criminal justice system. This gets conservatives on a field talking about race, talking about statistics dealing with race. It's not a comfortable field, Hans, because it's not about the color of one's skin. It's about the behaviors and the culture, quite frankly, and the breakdown of the American family, if we really want to identify it. Nevertheless, it's on that field where they're looking to jackpot somebody with a claim of bigotry. So my question in the long form is, do you agree that what we are seeing from the court in a 6-2 decision is the statement, hey, we understand what you're saying, but what you're doing is granting special rights and forwarding discrimination in order to eliminate discrimination, and that just doesn't work constitutionally?
Well, some of the justices said that. Now, others didn't. Justice Breyer joined the decision, which I'm sure was a big shock to progressives and liberals, because, of course, he's a very liberal justice. And he did say that that universities, for example, they can take race into account in college admissions unless the state bans it. Now, I think that's wrong. I don't think universities should be allowed to do that. And Justice Scalia and Thomas, I think, agree with that. But this really shows the moral bankruptcy, I think, of liberals today. That they've gone from wanting equal rights to wanting special rights, and that they are in favor of certain forms of discrimination. And look, the American people don't agree with them. The polling actually shows that the majority of Americans of all races think race-based college admissions is a wrong policy.
Amen. And again, does that mean that racism still doesn't exist? I you know what, Hans? I don't even know why I have to say that. It's just a stupid question. Of course, there are elements of racism. There's reverse racism, whatever you want to call it. It's out there, and there are ways to handle it and deal with it. I don't think, I do want to offer the other side's opinion and offer that argument, but when it's just so ridiculous, I'm bored with it. Tell me this, Hans, and I want to get to Eric Holder. Alabama had a voting irregularity in the sense of registration. What exactly took place in Alabama?
Well, they have found a number of counties there where the number of registered voters is larger than the census says they have a voting age population. So there's clearly a problem in those particular counties that they are not cleaning up their voter registration lists.
Attorney General Eric Holder, speaking to the issue of clemency, had this to say regarding a review of cases and drug offenders. Roll it.
Still too many people in federal prison who were sentenced under the old regime and who, as a result, will have to spend far more time in prison than they would if sentenced today for exactly the same crime. This is simply not right. The White House has indicated it wants to consider additional clemency applications to restore a degree of justice, fairness, and proportionality for deserving individuals who do not pose a threat to public safety. The Justice Department is committed to recommending as many qualified applicants as possible for reduced sentences. Later this week, the Deputy Attorney General will announce new criteria that the Department will consider when recommending applications for the President's review. This new and improved approach will make the criteria for clemency recommendation more expansive. This will allow the Department of Justice and the President to consider requests from a larger field of eligible individuals. As a society, we pay much too high a price whenever our system fails to deliver the just outcomes necessary to deter and punish crime, to keep us safe, and to ensure that those who have paid their debts have a chance to become productive citizens. Our expanded clemency application process will aid in this effort, and it will advance the aims of our innovative new Smart on Crime initiative to strengthen the criminal justice system, promote public safety, and deliver on the promise of equal justice under law.
A couple things struck me there, Hans. Regime? Am I unaware of a takeover here? And also, referring to, not directly to drug crimes, but I assume he's talking about sentences for the same crime that are disproportionate toward one group or another. I am concerned that each individual case is decided upon its merits, and we may be taking a look at data and changing what the authorities under the court system, the legal process, went through to determine what the correct length of punishment would be.
Well, look, you're right about this. I mean, look, there's two things going on here. I mean, one, look, the president certainly has the pardon power under the Constitution. I mean, that's an absolute power, and no one questions he's got the ability to do that. But then you have the the decision of whether is this good public policy or not. And think about this, Crane. Look, the president is in his sixth year of a term, and he's only now suddenly saying that, oh, there's a problem with the sentences of people convicted of drug crimes. Why is it suddenly happening now, right before the midterm elections? I mean, that makes it look like this is totally a politicized effort because the president and Holder think it's going to help them and their party in the upcoming election.
If they are taking this action with this, what about 2016 and immigration? With the potential, do you see a move? I realize we're talking clemency and pardoning power, but is there a way that they could make people that are now here illegally to give them the right to vote legally? Could they do that before, they being our president and the administration, could they do that before 2016?
No, not unless they got Congress to pass a law that would allow that in federal elections. You know, that they could not do. But look, it's very easy for somebody who's not a U.S. citizen to get registered and to vote in our elections. The chances of getting caught are just about nil. And I can tell you, even if you are caught, this administration has no interest whatsoever in prosecuting people because there's been evidence of this turned up over the past couple of years in state after state, and the administration has done absolutely nothing to actually investigate and prosecute any of those cases.
Final question. Advice for so many of us, including you, that you wrote a book on it and dedicated your life to upholding the rule of law and making sure that we keep our constitutional republic. Actually, it's a two-parter. One, is there a movement in the electoral process to get rid of the Electoral College? Do you see that as a potential threat in 2016 or later? And two, what can we do to make...
There's this thing called the National Popular Vote Plan. I think it's something like 10 states have already passed it. It's a compact, an agreement between the states that would basically bypass the Electoral College. And it's supposed to take effect when enough states have passed it, state legislatures have passed it that represent 270 electoral votes. And this has been very quietly going on all over the place, and they've unfortunately have been successful in getting it passed. And this is something that people ought to find out about and make sure that in their state legislators know this is a very bad idea.
10 states already.
I believe that's the number.
Wow.
Yeah.
Wow. Hans von Spakovsky, manager of the Election Reform Initiative at Heritage Action and senior legal fellow at the Heritage Foundation. I've posted your latest work on the Facebook, Hans, and I know people are clicking on it now for a more detailed analysis of the Michigan ruling. Bravo, sir, and thank you so much for going overtime with us. It's always good to talk with you, my friend.
Thank you, Crane. Bye-bye.
Take care. All right. Now,